Decades after the passage of other employment discrimination laws, disability rights groups were still fighting for a law which would facilitate the employment of people with disabilities. In 1990, they were rewarded with the passage of the Americans with Disabilities Act, or ADA. The ADA places upon employers the responsibility of making allowances for applicants and people with disabilities and prohibiting discrimination against them. When I worked as a federal investigator, I oversaw the investigation and negotiation of what was at the time the EEOC's largest settlement for disability discrimination. The ADA is a bit tricky. Knowing whether an employee with a disability has a right to a reasonable accommodation depends on several competing factors. I'm going to walk you through it step by step. To understand who is protected by the ADA, you need to know its unique vocabulary. A disability is a physical or mental impairment that substantially limits one or more major life activities. Some examples are alcoholism, certain back impairments, mental disabilities, and long COVID. A major life activity is anything that an average person can do, such as lifting, learning, performing manual tasks, and socializing, or the operation of a major bodily function, such as the immune, respiratory, and circulatory systems. A major life activity is substantially limited if the individual cannot perform the function or is substantially limited in the duration, frequency, or manner the function is performed as compared to an average person. So someone who is deaf has a disability because they are substantially limited in the major life activity of hearing. A person who needs to use a wheelchair is substantially limited in the major life activities of standing and walking. Here's another example. A person with a hip disorder can walk, but with difficulty. They have trouble keeping their balance and can only walk 15 steps at a time before needing to stop. Walking is substantially limited for this person because of the duration, frequency, and manner of their walking. The nature and severity of the condition, as well as the duration or expected duration and impact of the condition, also indicates whether an individual is substantially limited. Impairments are not substantially limiting if they are of short duration and do not have lasting effects. Let's say a woman falls off a ladder and breaks her leg and is confined to a cast and must use crutches to walk. After 6 weeks, she is expected to make a full recovery. Her impairment would not have a lasting effect and is of too short of a duration to be considered a disability. An impairment that lasts or is expected to last less than 3 months is too short to be considered a disability by the courts. An impairment that is expected to continue for more than 6 months may be considered sufficient duration for a disability, but shorter-term impairments might also be considered substantially limiting. The duration of the impairment needs to be considered alongside the nature, severity, and impact of the condition. The ADA specifically states that the definition of disability should be understood to favor broad coverage of individuals. Whether an impairment is episodic or in remission has no bearing on the definition of disability. An impairment that, when active, substantially limits a major life activity is a disability. Medication, assistive equipment, and other modifications that reduce or eliminate the symptoms of a disability also have no impact on the determination of whether an individual has a disability. A person with diabetes who would be incapacitated without insulin still has a disability, even if they are completely fine when taking insulin. The only exception is that the corrective effect of ordinary eyeglasses and contact lenses are taken into account when determining whether an impairment substantially limits a major life activity. After you prove you have a disability, the next essential step is proving that you are qualified for the position for which you are applying or in which you are working. An employee is qualified if they can perform the essential functions of the position with a reasonable accommodation if necessary. An applicant with a disability must also have the skill, experience, and education required for the position. Essential functions are the most important parts of a job. A job function is essential if the job exists to perform that task, or if the task is specialized and can only be performed by a few people. In addition to the job description, evidence used to determine whether a job task is essential is the amount of time spent performing the task, the consequences if the employee does not perform the task, and the work experiences of past or current employees in the job. The ability to perform other non-essential, secondary tasks included in a job description cannot be used to screen out a person with a disability. For example, let's say a deli worker can only lift 12 pounds. They can perform all the essential functions of their position, but cannot take the garbage out at the end of their shift. This infrequent duty cannot be used to prevent the deli worker from working in their job. If you are qualified for a position and have a disability, you are a protected individual under the ADA. A qualified individual with a disability is commonly referred to as a quid. Basically, a quid is someone who cannot do something that most people can, but can do the important parts of their job with a reasonable accommodation if necessary. To be protected by the ADA, a quid must straddle this line of being substantially limited, but not so substantially limited that they cannot perform the essential functions of the job. Quids often need reasonable accommodations to perform their jobs. A reasonable accommodation is an adaptation that would allow you to perform the essential functions of your job. For a receptionist with a back and neck impairment that limits them in the major life activity of sitting, a reasonable accommodation request would be for an ergonomic chair and a telephone headset. These accommodations allow them to perform their job with minimal pain. A reasonable accommodation could entail adjustments to a work environment or modifications in the manner or circumstances that a job is customarily performed, so you can enjoy the benefits and privileges equal to those enjoyed by other employees. To provide you with an accommodation, your employer must be aware of your need for an accommodation. Your employer will likely be unaware of your need for an accommodation until you have made the request. If a possible accommodation exists and your employer fails to provide it, your employer has violated the law. You do not have to suggest exactly what accommodation would allow you to continue working, but you need to participate in a dialogue with your employer to determine what accommodations are necessary and appropriate. When the need for accommodation is not obvious, your employer can ask for documentation that supports your need for an accommodation. Your employer will likely have a number of options from which to choose an appropriate accommodation. While your employer must provide a reasonable accommodation, it is not required to provide the accommodation that you prefer. A reasonable accommodation cannot eliminate an essential function of a job, but it can alter how and when that task is performed. There may be no reasonable accommodation that would allow you to perform the essential functions of your position. The accommodation of last resort would be to place you in another vacant position for which you are qualified and can perform with or without accommodations. You do not have to apply for the position, and if others are also being considered, you do not need to be the most qualified candidate. If no equivalent positions are available, then your employer may place you into a lower graded position. Your employer is not required to bump another employee out of a position, place you into a position that would be a promotion, or create a position for you. The purpose of a reasonable accommodation is to allow you to perform a job. A leave of absence is a reasonable accommodation because it allows you time to get your disability under control so you can return to work. Your employer is not required to grant a request for an indefinite leave of absence, as this is not a reasonable accommodation. On the other hand, your employer could run afoul of the ADA if they limit their leaves of absence to the maximum allowable under their own policies or the minimum required under the Family Medical Leave Act. If you request a leave of absence or an extension of a leave of absence, your employer must conduct an individualized assessment to determine whether granting your request would cause an undue hardship. Your employer does not have to provide a reasonable accommodation under the ADA if it causes an undue hardship. An undue hardship is a significant difficulty or expense for the employer. Some of the considerations for an undue hardship are the financial and personal resources of the employer, the cost of the accommodation, the impact of the accommodation on the employer, and the ability of other employees to perform their jobs. Employee and customer prejudices are irrelevant considerations for determining undue hardship. Any accommodation that is unduly costly, extensive, disruptive, or fundamentally alters the nature and operation of a business causes an undue hardship. If the cost of an accommodation creates an undue hardship, you must be given the option to pay for the accommodation or for the portion of the cost which creates the undue hardship. Most accommodations will not place an undue hardship on an employer. A job accommodation network survey found 58% of accommodations cost nothing, while the remainder cost only $500 on average. When a reasonable accommodation exists, your employer is not exempted from its obligation because it was unable to identify this accommodation. Technical assistance is readily available from federal agencies that administer the ADA, like the Job Accommodation Network or the ADA National Network. The ADA has many of the same protections as Title VII. An employer cannot segregate or classify an employee based on their disability, like placing quids on a separate promotion track or allowing them only in a particular break room. Disparate impact cases, where an employer's policy disproportionately affects protected individuals, is different under the ADA. A policy or job requirement that unequally impacts even one quid creates a disparate impact. A statistically significant number of quids is not required. In this situation, your employer must defend a policy or job requirement that negatively impacts you by proving it is job-related and consistent with business necessity. For example, the barista job description states lifting 50 pounds is an essential function of the position, but an applicant with a disability can only lift 30. While it initially appears they are not qualified for the position, the employer must be able to defend that lifting 50 pounds is job-related and consistent with business necessity. If the incumbent only needs to lift 25 pounds, then lifting 25 pounds would be job-related and consistent with business necessity. Even if your employer can establish that a policy is job-related and consistent with business necessity, it may still be required to provide a reasonable accommodation that would allow you to comply with the policy. Let's say the policy of the State Department of Agriculture is that research technicians must spend 2 weeks each year in the field taking soil and water samples. This policy has a disparate impact on a blind employee who cannot navigate the unfamiliar territory. Let's say this policy is job-related and consistent with business necessity. The department must provide a reasonable accommodation to the blind employee, such as providing an assistant for 2 weeks. Employers have more latitude when establishing leave policies and benefit plans. This includes policies prohibiting employees from taking sick leave after their first year of employment, or policies delaying the onset of benefits. One of these policies or plans can be the subject of a disparate impact case only if it was created to intentionally discriminate against a quid or quids, is inconsistently enforced, or targets people with particular disabilities. So a policy that employees cannot be absent for the first 6 months could not create a disparate impact for a quid. Even so, that would not preclude them from requesting a reasonable accommodation, such as leave without pay. If you're finding this information helpful, please subscribe to the channel so you don't miss out on getting the information you need. In addition to quids, there are 3 other groups who are protected by the ADA. An individual who is perceived as having a disability is protected against discrimination. This individual may or may not have an impairment. Contagious diseases or physical disfigurement could be regarded as disabilities. Those regarded as having disabilities could include those who are perceived as being illegal drug users or alcoholics. If you are treated by an employer as having a disability, you are protected by the ADA. Congress's intention for including this safeguard was the realization that myths, fears, and stereotypes associated with disabilities can be as stigmatizing as the disabilities themselves. Potential fears include increased health insurance and workers' compensation costs, additional expenses from reasonable accommodations and increased liability, poor productivity, inconsistent attendance, employee or client discomfort, and increased safety risks. When regarded as having a disability, it is essential to identify these myths, fears, and stereotypes to establish the discriminatory motive. You cannot be regarded as having a disability if you have a minor impairment that lasts or is expected to last 6 months or less. Nothing in the ADA prevents an employer from taking adverse actions against an employee with a temporary minor impairment. Discrimination against you because you have a record of a disability is also forbidden. This provision prevents discrimination against people who are misclassified as having a disability or who have had a disability previously. This prohibition applies to all documents, including medical and employment records that disclose that a disability formerly existed. The ADA also prohibits discrimination against you because of your association with a person with a disability. If you are regarded as having a disability, have a record of a disability, or associate with a person with a disability, you do not have a right to a reasonable accommodation. An employer is required to provide accommodations only to quids.
Whew, that was a lot of information. If you grokked all that, give yourself a pat on the back. This stuff is complicated. Okay, ready for more? Stretch a little bit. Ugh. Okay. All right, let's get back into it. But from here, you can skip around. Now that you know the fundamental principles, we can consider more difficult questions. Do asthmatics have disabilities? Do illegal drug users and alcoholics? Can someone have a disability because they're overweight? What about people with infectious diseases or mental health disabilities? If these questions do not relate to your situation, jump to the next section. Illegal drug users are not protected by the ADA until they enter a rehabilitation program. People with alcoholism may have a disability, but can be held to the same standards as other employees if the alcohol use adversely affects their job performance. After participating in a rehabilitation program, like Narcotics Anonymous or Alcoholics Anonymous, illegal drug users and alcoholics are protected from discrimination based on having a record of a disability. An overweight individual has a disability if they are substantially limited in a major life activity. Usually, morbid obesity is required along with a medical cause for the obesity. Overweight people may be regarded as having a disability even if their weight does not have a medical cause or limit a major life activity. Infectious diseases like tuberculosis and HIV are impairments of major bodily functions, respiratory and immune functions, respectively. If a disease substantially limits a major life activity, then an individual with the disease is protected by the ADA. Even if the disease does not rise to the level of a disability, an individual with the disease may still be regarded as having a disability. Individuals with mental health disabilities have unique challenges on the job.
most courts agree that an employee with a mental health condition can be disciplined for misconduct on the job, even if the disability causes the misconduct. The exception is if the employer denied the employee's request for a reasonable accommodation that would have prevented the misconduct. Some impairments only rise to the level of a disability based on their severity. Asthma, for example, may or may not be a disability depending upon the seriousness of the condition. Some people diagnosed with asthma are not significantly limited in breathing, using an inhaler rarely or not at all. Other people with asthma have debilitating attacks that last for days and require medically supervised administration of steroids. An employer does not have to employ someone who poses a direct threat to themselves or others. To establish a direct threat, an employer must establish a high probability of substantial harm based on medical information, input from the quid, or experience with the quid in similar situations, define the specific reason for the risk, the duration of the risk, the nature and severity of the potential harm, and the likelihood of the potential harm, and prove the risk is current and not speculation of future harm. A direct threat cannot be substantiated by irrational fears, subjective perceptions, or general fears about an individual's safety during an emergency or evacuation. Even if an employee poses a direct threat, an employer must provide reasonable accommodations that would reduce or eliminate that threat. Let's say a heavy crane operator develops narcolepsy, resulting in them falling asleep uncontrollably. Because of their disability, they could pose a direct threat through their use of heavy machinery. They could be reassigned to a position as a truck loader as a reasonable accommodation. The ADA wants quids to be hired and takes great pains to prevent employers from discriminating against applicants with disabilities. The restrictions placed on employers make it very difficult for an employer to learn about an applicant's non-obvious disability prior to making a job offer. Before offering you a job, an employer cannot ask anything likely to garner information about a disability. During a job interview or on a written application, an employer's inquiries must be carefully constructed. Examples of illegal questions are: have you ever filed for workers' compensation? Have you had a serious illness in the past 5 years? Have you ever had any of the following diseases? Followed by a list of diseases. It is legal to ask, can you perform the essential functions of the job with or without a reasonable accommodation? Or, for obvious disabilities that might interfere with the performance of essential functions, how, with or without a reasonable accommodation, will you be able to perform the essential functions of the job? An employer can require a drug test, but can only test for the 5 types of illegal drugs: amphetamines such as MDMA or speed, cocaine, marijuana, PCP, and opiates. An employer must be careful when checking references. An employer can ask past employers about an applicant's attendance, but cannot ask if you missed work because you were sick. Even if you volunteer information about a disability during an interview, an employer still cannot ask follow-up questions about the disability. If you need a reasonable accommodation to participate in the application process, the employer must provide one. You must notify the employer of your need for an accommodation before you actually need the accommodation, or when you first become aware of the need. If the disability or need for accommodation is not obvious, the employer can ask you for documentation of the disability or the need for the accommodation as it relates to the application process. An employer cannot prefer an individual without a disability over a quid simply because the quid needs an accommodation. You cannot be denied a job because your disability prevents you from being able to perform a non-essential job duty. The employer must be aware that the reason you cannot perform the non-essential function is because of a disability. Otherwise, the employer can refuse to hire you because you cannot perform the task. An employer must complete as many parts of the hiring process as possible before offering employment to you, such as interviews and checking references. Once an employer offers you a job, the employer is free to ask questions that might elicit information about a disability. An employer can require you to submit to medical examinations before you start working. However, an employer requiring a medical exam must test all applicants in a particular job category. An employer can require you to submit to drug tests. If the results show the presence of prescription drugs, the employer must analyze whether the legally prescribed medication would interfere with your ability to perform the job. Before you start work, an employer's medical exams and testing standards themselves do not have to be job-related and consistent with business necessity. Employers have considerable latitude when selecting medical exams and tests for new employees who have not started working. But if an employer wants to rescind a job offer based on test results, the test or standard that is used to deny hiring you does have to be job-related and consistent with business necessity. An employer may not ask you to complete a medical questionnaire with questions that ask about your family's history of medical conditions. The Genetic Information Non-Discrimination Act prohibits employers from asking about family members' health conditions. Information from permitted medical exams must be treated confidentially. Medical information must be kept in a confidential file separate from the employee's other personnel records and access limited. Supervisors may be informed about necessary work restrictions and accommodations for you. Medical information cannot be used for purposes counter to the ADA, including limiting your insurance coverage. Once you begin working, your employer can require medical tests only if they are job-related and required by business necessity. There are a few exemptions. If evidence exists that your job performance is a safety problem, when required by federal law, if you volunteer as part of a voluntary employee safety or wellness program, if you need a reasonable accommodation, an employer can require medical documentation that you have a disability and/or need the accommodation, unless the disability and/or need for the accommodation is obvious. Documentation of a disability should include a list of major life activities that are substantially limited, the prognosis, whether the symptoms will worsen, improve, or remain stable over time, and treatment. You may also include your diagnosis unless there is a reason you do not want your employer to know of your diagnosis. For example, an individual with a mental health disability may be concerned about worsening treatment if their employer learns of their disability and holds stereotypes about people with this condition. Documentation of an accommodation request should include a brief explanation of the limitations caused by the disability. In the case of an illegal drug user, the employer can request certification that an employee is participating in a drug treatment program and/or evidence, like a drug test, that the employee is no longer using illegal drugs. If an injury or illness causes you to be unable to perform the essential functions of your position, and your employer has a reasonable concern that you can still not perform the essential functions of your position, your employer can request medical documentation that you can perform the essential functions of your position before you return to work. These are often called return to work releases. If you provide the requested documentation for a reasonable accommodation or to return to work, your employer must accept this documentation as accurate unless it has some reason to doubt the documentation. If your employer has a reason for doubt, it can conduct an exam. The scope of the exam must be limited to uncover only the requested information. For example, if the purpose of the exam is to explore the need for a reasonable accommodation, the exam can only focus on the limitations caused by your disability. Your employer cannot require you to be 100% recovered before returning to work. As long as you can perform the essential functions of your job, with or without a reasonable accommodation, your employer cannot deny your return to work. If your employer refuses to reinstate you when you can perform your regular duties, it could be violating the ADA because it is failing to accommodate you, regarding you as having a disability, or both. An employer can provide periodic exams for employees in safety-sensitive positions to test their ability to perform safely. In this case, the employer must require all employees in that position to submit to periodic exams. Random drug tests are allowed under the ADA even for positions that are not safety sensitive. Under the Affordable Care Act, an employer with 50 or more full-time employees is required to provide health insurance to employees or pay a fine. If an employer chooses to provide health insurance, the health insurance plan cannot exclude particular individuals with disabilities. Limitations on the number of days covered in a hospital stay and other policy limitations are legal as long as they are not administered in a way that discriminates against people with disabilities. For example, a policy cannot set a lower cap for insurance benefits for individuals with AIDS than for other conditions, but a policy can cap benefits for all benefits at $100,000. An employer is not required to create a light-duty job that reduces the physical demands of the position if performing such tasks are part of the essential job functions. If a vacant light-duty position exists, a possible reasonable accommodation would be to place you in the position. If the light-duty position is temporary, so is the employer's duty to place you in that position. An employer may not offer light-duty positions only to certain employees, but not others. For example, allowing employees with work-related injuries to work light duty while not allowing employees with disabilities to work light duty would violate the ADA. A disability retirement plan is not required under the ADA. If an employer provides one, it can provide any benefits it chooses as long as it doesn't offer different benefits for particular disabilities. These benefits can be substantially lower than what you would have received under a service retirement plan if you had worked longer. Many employees injured on the job do not have disabilities. Often, employees will recover fully after short periods of time. Workers' compensation makes restitution to employees injured on the job. Discrimination against you because of a workplace injury or because of participation in the workers' compensation process is illegal, and you can file a workers' compensation complaint with your state workers' compensation agency. The U.S. Department of Labor's Office of Workers' Compensation Programs defines a disability differently than the ADA. An employee could be temporarily injured and be considered partially disabled under workers' compensation, but not under the ADA. Many employees receiving workers' compensation benefits are not disabled under the ADA. Does a qualified individual with a disability have a right to return to their same job? It depends on the employer's practice of holding jobs open for individuals without disabilities who are absent for an equal period of time. An employer who holds jobs open for people without disabilities who go on leave must do the same for quids. Even if an employer is not required to hold a job open, it still has a responsibility to provide the reasonable accommodation of reassignment to another position. Another option exists for employees needing time off work for medical reasons. The Family Medical Leave Act gives employees up to 12 weeks off per year because of a serious health condition. Employees can also receive leave for childbirth, to care for a seriously ill spouse or family member related by blood, or for placement of a child due to adoption or foster care. In a 5-4 decision, the Supreme Court ruled state employees are not entitled to any monetary damages for discrimination based on a disability. Monetary damages for disability discrimination are available to state employees under many state and local laws. States can still be required to provide non-monetary relief, which I'll discuss in a future video. Now you know all about disability discrimination. If you'd like to know more about another basis of discrimination, like LGBTQ+, please check out the appropriate video in this series. Otherwise, check out the video which discusses retaliation. You need to know how to be protected when complaining about discrimination. If this video was helpful to you, please click the like button. And if you've experienced discrimination based on your disability or needed an accommodation because of your disability and have any tips that might be helpful to others, please share them in the comments below. Thanks for tuning in.